not need it.
Okay.
So the difference on that is, well, I'm actually, well, I'll explain to you here in a moment. Yeah.
Offer.
Okay.
I just never know if you're doing an arraignment or doing what you're doing with them. So.
I'm on the YouTube now. I'll explain it to you as soon as we get done.
Okay.
Yeah.
Okay.
So there's a difference between an initial appearance and an arraignment. Sometimes those can be combined. So like somebody gets arrested last night, I see him today. If I'm setting a court date out, that's an initial appearance. Sometimes like a driving suspended, I'll go ahead and arraign them too. That's when I advise them of the fines, the penalties and all that. Big deal. That's what I do on a Wednesday in the morning. So sometimes I'll do it all together. Many times I don't do that on initial appearance. I just release them, send them for the next court date for you. Sometimes I'll do it together. It just depends on the type of case. You can't do it on victims. Or if I do, I've got to set it for a pretrial or a sentencing. Try to give them a little bit of time to think about it. So that's why we set the dates out. But if there's a reason not to, and I do an arraignment, that's where advisory rights and all that, then that's where I need the record. I don't need to have a record on initial appearance, but I do need one by arraignment.
Well, what's the difference? When are you doing arraignments? You're doing that at the same time as IAs at 1:30. Sometimes.
Most of the times are on the Wednesday mornings.
Okay. Okay.
Sometimes I will on a case like a driving suspended. I don't want to have to schedule them back out of California or whatever. So we get it done now.
Okay.
So there's a few times where I'll do it all together.
Okay.
All set.
Thank you.
All right, sir, I'll get the first one.
Okay.
Oh, sorry. Okay. Right here. For the city full name for the judge. Charles Eugene Underwood III.
All right, sir.
All right, the state is alleging 3 charges against you. 2 of them are felony allegations, and 1 of them is a misdemeanor allegation. The 2 felony allegations are dangerous drug possession or use. The second charge that's a felony allegation is drug paraphernalia possession or use. The misdemeanor allegation is driving with a suspended, revoked, or canceled driver's license. On both of those charges, you have the right to remain silent, right to counsel, and right to trial. On the felony allegations, I've scheduled you for a court date for a preliminary hearing on the 12th of January at 4:00 p.m. The preliminary hearing is to determine if there's probable cause to charge you with those 2 felonies, not convict you. If probable cause is found after that hearing, your case will bind over to the Gila County Superior Court. If probable cause is not found, then your case on the felony side will be dismissed. The driving suspended, revoked, or canceled, we have one of 2 things. I can schedule you at a later court date to appear to give a plea, or I can explain to you your rights now on the misdemeanor violation and take a plea from you now if you wish to do that. Do you have an option?
Later.
Okay, you'd like to do it now?
Later.
Okay, so with that being said, what I'm going to do is need your permission to waive your personal appearance on the misdemeanor and go do this by video. Do I have your permission?
Yes.
Okay, give me one moment. Let me explain to you the felony side while I'm waiting on the other portion of, so on the felony, hi there. So we do need a record on half of this case, I'm sorry.
That's okay.
So I'm gonna go back to the misdemeanor, the driving suspended violation is a class 1 misdemeanor that has a maximum penalty of $2,500, 6 months in jail, and or 3 years of probation. As of now, there is no jail time being asked of this case on this misdemeanor charge. So you're not facing any jail time if you plead guilty or plead no contest, or if you're found guilty after a trial. If that changes, your rights will change, and you'll be advised of that when that occurs, if it occurs. So your choices are to plead guilty, not guilty, or no contest. The difference between a guilty plea and a no contest plea is if you plead guilty, you're admitting to the facts of the case, and you're admitting that you committed the crime. A no contest plea means
No contest.
Okay, I still have to make sure that you
I understand what you're saying.
Doesn't matter.
All right.
So I have to tell you your rights. I have to say this all on record, and then I'll ask for your response. So a no contest plea means that you're not admitting or denying the facts of the case, but you're accepting the conviction. Both a no contest and a guilty plea, both a no contest plea and a guilty plea show up on a criminal history. Are you doing okay?
Not really, no.
Okay, do you feel ill?
Yeah.
Do you need to have medical sent to you? Okay.
No, I'm just trying to get this done so I can go home.
Okay, do you understand everything that I'm saying?
Yes, I do.
I know that you're tired and you're yawning a lot. That's probably the coming down part on these allegations.
Yeah.
Okay, so, but you understand what I'm saying?
Yes, I do.
Okay. All right, so that I explained to you the difference between a guilty plea and a no contest plea. You also have the right to have an attorney on the misdemeanor case. Since there's no jail time, you don't have the right to a court-appointed attorney on the misdemeanor side. So your choices are to waive the personal appearance and waive the presence of an attorney, or hire an attorney at your own expense. Do you understand that? Yeah. Okay, do you want to hire an attorney at your own expense or waive the appearance?
Waive the appearance.
All right, I'll be sending you an attorney waiver form and a personal appearance form all on the same document. Just requires you to sign it. You indicated on record that you're waiving the presence of an attorney. All right, and you earlier, you don't have any questions on the 3 options of the plea, right? So you entered a plea of no contest. Do you wish to remain with that plea? All right. So with that plea, I need to advise you of the rights that you're giving up by pleading no contest, okay? First off, are you on probation or parole?
No.
I'm sorry?
No.
Okay. By pleading no contest, these are the rights that you're giving up. Number 1 is the right to plead not guilty and require the state to prove your guilt beyond a reasonable doubt. 2 is the right to have a trial in front of a judge. 3 is the right to the assistance of an attorney at all stages of the proceeding, including appeal, and that's where I talked about the attorney waiver form. Also, you're given up the right to confront witnesses against you and cross-examine them as to the truthfulness of their testimony. You're given up the right to cross-examine or the right to present evidence in your own behalf and subpoena your own witnesses. You're also given up the right to remain silent and to be presumed innocent until proven guilty beyond a reasonable doubt, and also the right to a direct appeal. I need to make you aware of possible collateral consequences with your no contest plea on a driving suspended. That is the possible suspension of your driver's license, an impact on a commercial driver's license or other professional license, an impact on your insurance rates, the revocation of probation or parole, an increased penalty for further criminal charges, becoming a prohibited possessor if convicted of domestic violence charges, and if you're not a citizen of the United States, a plea or finding of guilt may result in deportation or being denied citizenship or reentry. Further on your citizenship, I must read you at Rule 17.2 is that if you're not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation even if the charge is later dismissed. Your plea or admission of guilt could result in your deportation or prevent you from ever being able to get legal status in the United States or prevent you from becoming a United States citizen. Understanding each of these rights I've just read to you, you wish to waive those rights and enter your no contest plea?
Yes.
Okay. You may file a Rule 33 petition for post-conviction relief, and if denied, file a petition for review. I'll give you a letter that explains that. It'll also explain to you how to set aside the judgment of this conviction pursuant to Arizona Revised Statutes 13905. Once all the terms of the sentence are completed and you may qualify for a certificate of second chance and apply to seal the records pursuant to Arizona Revised Statutes 13911 once the terms of the sentence therein have been satisfied. I'm going to read you the factual basis of the driving suspended violation. You're not admitting or denying those facts, but accepting those facts that would be used against you if a trial were to take place with your no contest plea. On January 1st of 2026 at about 3:13 p.m., you were contacted by the Payson Police Department at or near the 200 block of South Bentley Street. In that police contact, it was found that you were driving a motor vehicle on a public roadway while your license was suspended, revoked, or canceled. That occurred in Payson city limits in Gila County in the jurisdiction of this court. And you are here today pleading no contest to that violation. Does that sound correct?
Yes.
I'm sorry, sir?
Yes.
Okay. Regarding your plea of no contest, are you making that voluntarily?
Yes.
Nobody forced, threatened, or harassed you to plead that?
No.
Okay. Did anybody promise you either lighter sentence or punishment? Okay. The court finds that you entered your plea of no contest knowingly, voluntarily, and intelligently will accept your plea. I'll be sending you a form that looks like this. It has the information that's listed that we went over, the rights that you're waiving. You're required to sign that document. Do you wish to give a statement to the court before we impose sentencing on the driving suspended? No? All right. The standard fine, sir, is $482. If you're able to get a license within 30 days of today's date, I'll reduce that amount to $202. If not, then you're just fined that $482. I'm giving you credit for 1 day of in custody on the arrest. There's a jail fee of $69. That brings a total balance to $551. Are you currently making payments to the court? No? Okay. Can you pay that $551?
Not all at once.
Okay, I can put you on a payment plan. I have to add a $20 payment plan fee. What can you afford per month?
For $20?
Court minimum's $25, so I'll put a $25 minimum on it.
Okay.
I'll make your first payment due in 30 days from today's date. Give me a moment. It's going to be a little bit over 30 days because of the other felony stuff you have to deal with. So it'll be the first payment's due on February 6th of 2026 of $25. That will be a form called the Judgment and Sentencing that requires your signature as well. I'll also provide you with the information that I talked about regarding how to set aside judgment and seal the records. So those documents will be coming to you shortly, okay? That'll release you on the misdemeanor violation. Now we'll continue to talk about the felonies. Your release condition on those are to obey all orders of the court, do not commit any crimes, notify the court immediately of any change of address, do not leave the state of Arizona without permission of the court, do not consume or possess any alcohol or drugs without a valid prescription, and do not possess any firearms because of the felony allegation. So I'm either going to do one of two things, release you to a treatment facility because of your priors and your prior arrests that are recent, or place a $1,000 bond hold on you. So I want to explain the bond. If you decide you don't want to, okay, let me explain the process to you. And then but you're not going to just go out and walk on the street, because we've done that already and you're reoffended. So you need counseling for your addiction or the issues that are alleged against you. So you can tell me that I want to go to counseling and they're going to come down there and pick you up and take you there, or you can sit there with a $1,000 bond over your head until the next court date.
Is there any way that I can get picked up and get dropped out there by myself? I have my dogs and my girl. I gotta get in order before I do all this.
Okay, so let me tell you the process here. Okay, let's say you choose not to go into counseling. That bond will remain in place, but the prosecutor is required to file a complaint within 48 hours. Now those are business days. If they don't file that complaint, then you'll be released on your own. Okay, you don't have to come up with a bond, you'll be released. But that's 48 business hours, so that doesn't count the weekend. So you'd be in here past the weekend, and on Tuesday, if they don't have the complaint, you could be released by then. Okay, so you're
down. I'm super sick right now.
So yeah, so what you need to do, sir, is when they come there, just talk to them about your dogs and all that, and they'll try to assist you to take care of those animals, okay? If you need to make some phone calls, talk to the detention staff to get a buddy or somebody to help you with that. But if that's what you want to do, then you'll have to go with them to the treatment, and then otherwise the bond's in place, okay? Any questions on that?
No.
Okay. All right, then we'll get that information sent over right away.
Right, sir. Yeah.
Give us.
Yeah, I'm okay.
Hi there, sir. Can you state your name?
Oliver Jones,
Okay, your full name, sir?
Oliver J. Jones Jr.
Thank you. The state is alleging 3 charges against you. One is disorderly conduct under the domestic violence statute. The second one is assault under the domestic violence statute. And the third one is resisting arrest. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for an arraignment on the 12th of January at 1:15. The arraignment is where you'll need to be prepared to plead either guilty, not guilty, or no contest to those charges. Depending on how you plead will be what happens next with the court proceeding, and all of those options as well as the penalty range will be explained to you prior to you getting your plea on that date, so you'll be well informed. Your release conditions are as follows: obey all orders of the court, do not commit any crimes, notify the court immediately of a change of address, do not leave the state of Arizona without permission of the court, do not contact the alleged victim with unwanted contact. So that means that you and the other party can speak unless they tell you they don't want to, okay?
Husband.
Pardon me?
It's my husband.
Okay, I understand that, but It doesn't matter who it is. If you're not allowed to talk to them if they don't want to talk to you. Otherwise, you violate this order and you'll be placed right back in here.
But I have court on the 8th in Phoenix. So, because that's where we're from, is Phoenix.
Okay. So let me finish the other conditions. The other part is that you may not go to the location of the alleged offense. So if you resided there together, that no longer is happening. This isn't a permanent order, but this is a temporary order while this goes through the court process, okay?
Okay, well, my property and my dog are there currently.
Okay, so you can go back there with law enforcement and have a civil standby done to where you can collect your personal property and your animals if you choose to, and you just contact the police ahead of time to go there with you, but you're not allowed to go there without their presence. Do you understand that? You don't you do understand?
Yeah.
Okay. All right, sir. There's so this offense you just had a recent prior one. Did you have? Yeah, that one that you're talking about in court. In court, right?
Yeah, I have to be to court on the 8th.
Okay. Well, so I'm placing a hold on you on this. That's why I did the court date only 10 days from now. So that's a very soon court date. That's 10 days from now. So there's $1,000 bond hold on you.
Well, no, but like I've never been in trouble in your county or anything before. I deserve to be OR'd.
Well, you and I might have a difference of opinion.
No, because I've never been in trouble in your county.
Here's why.
Well, dude, I can see why. Like I can understand why, but no, that's bull crap. Because I have stuff to do. I work. I have fucking a court date coming up. This is not okay. No,
Okay.
I cannot be held. I need to be OR'd, please.
Okay, that's not going to happen. So
I don't want. I can't just sit here for 10 days.
Okay, you can bond out with $1,000 bond, sir.
$1,000 that I don't have currently.
Okay.
Because, no, that's not okay.
Okay, then we'll see you in 10 days.
No, come on,
Thank
please.
you, sir. That's all I've got for you.
No, please. Can we finish this?
Go.
No, this is bullshit. I can't sit here for 10 days. That fucks up my other court date. Stop. No, that's not fucking okay. I cannot sit in this shitty fucking jail for 10 fucking days.
Your choice on how this wants to go.